Anyone who has stood in line at Disney or a theme park or even a national park where you've got young kids and you're waiting to use the bathroom, you know it's annoying. Getting in line for an immigration benefit is not the same as getting in line for the bathroom. We can all agree that it's really crappy, pun intended, to cut in line for the bathroom. Especially if you're a woman and you've already been waiting 10 to 15 minutes to use that bathroom. But the so-called line for immigration status is not actually a line at all. It looks more like a Pac-Man screen, where you have a labyrinth and a bunch of different things that you're trying to catch, or like people running around. And so it isn't actually a line at all. It's pandemonium for many people. On the first day of my job at a nonprofit law office, an immigration roadmap greeted me. It looked like a hybrid of a sorry board, chutes and ladders, and a multitude of other board games, all combined into one. There were red sorry boxes that indicated that you weren't actually going to get that coveted green card, and then there were just a few green boxes for that coveted green card. And I looked at my supervising attorney and I said, "This is a joke, right?" And she said, "No, actually the attorney before you used it during every consultation with his clients." There are a lot more lines on this immigration roadmap running to the sorry box. In fact, there are 18 lines running to that sorry box, whereas there are only 6 running to the green card box. Within that first category of employment-based immigration, only those with extraordinary ability, documented achievement, or specialized knowledge, or even those who can invest $1 million in the local economy are eligible for that type of visa. There are some visas for short-term unskilled workers. There are other visas that are given for people working in specialty occupations, and about 5,000 visas each year are given to people who are not highly skilled. But those people who are already living in the United States undocumented are not able to get on that immigration path. Within that larger category of family immigration, it is tightly limited to the following. U.S. citizens may petition their spouses, their minor children under the age of 21, their adult children over the age of 21, both married and unmarried, and their parents. Lawful permanent residents are only able to petition their spouses, their minor children under the age of 21, and their unmarried children over the age of 21. So no grandchildren, no grandparents, no nieces, no nephews, no cousins, no aunts, no uncles. What makes this category even more complicated is grounds of inadmissibility, which applies to non-citizens seeking admission to the United States. Those who are found inadmissible are not permitted to enter or remain in the United States. One of these grounds of inadmissibility is unlawful presence, or living here without lawful status. Those currently living in the United States without immigration status are accruing what's called unlawful presence. This unlawful presence creates a bar to admissibility. The Illegal Immigration and Immigrant Responsibility Act, or IRA, passed in 1996 by the Clinton administration, created these bars. And while there is a waiver available for this particular ground of inadmissibility, it's not available to all, if not most, of undocumented immigrants living within our borders today. Only those who can show that a U.S. citizen or lawful permanent spouse or parent would suffer extreme hardship are able to invoke this remedy. This means that all of those parents of U.S. citizen children who were hoping to gain lawful permanent residence through a child are not able to do so because they don't qualify for that particular waiver. And that is the only way that they would be able to gain lawful permanent resident without serving that bar in another country. So they keep running into that big sorry sign. And this, among other things, is why millions of undocumented immigrants in our country today don't just get in line. Now ask yourself, when did your ancestors arrive into the United States? Was it prior to 1882? Was it before 1924? If the answer to either one of these questions is yes, then your ancestors did not enter the legal way, because prior to 1882, there was no federal immigration law. And between 1892 and 1924, 90% of those immigrants seeking entrance into the United States were permitted to enter without a visa. It was also during the same time that we had an extremely racist quota system that favored white Northern European immigrants. Now, despite changes to immigration law, we see this white favoritism continue. And it persists due to a pervasive white power structure giving systemic preference and privilege to white men and women. In 1965, Lyndon B. Johnson passed the Immigration and Nationality Act, which did away with that former quota system and instead prioritized family connections and work skills. But as part of the Immigration and Nationality Act, only 7% of total visas could go to any one country. So competition for a visa from countries like Mexico was incredibly steep, whereas in Mongolia, where sheep outnumber people, competition is a lot less steep. Because of this quota system, some people will wait more than half of their lifetimes, or up to 40 years, for a visa to become available that allows them to reunify with their family here in the United States. To further complicate this issue, we have, on the one hand, people who can't get in line, and on the other hand, we need them here. We demand that they be here to perform some of the most fundamental jobs in our labor system. So millions of residents in the United States are stuck in this catch-22, where U.S. employers are actively recruiting them to work jobs in the fields, in dairy farms, or in factories. And on the other hand, we have U.S. groups, the government included, who are actively trying to remove them, that are demanding that they leave. These groups, again, the government included, are making demands that this population, quote, do it the legal way, but are actively creating policies and making rules that make it nearly impossible for this group to do it the legal way, or create this overall chilling effect that make them fearful of taking steps to legalize their immigration status. The current administration seems to think that it is discouraging further illegal immigration to the United States through these harsh and abusive tactics, but it is in fact not differentiating between those who are already here in the United States working lawfully or unlawfully and those who are still coming. Regardless of immigration status, lawful or unlawful, everyone is suspect in this paradigm. This idea that there is a system that works, that is fair, and that there are people who just refuse to use it, this is wrong. It's a myth. As I hope I've demonstrated in this short presentation, the system that we have today is completely different from the system of our ancestors because it dramatically changed in 1965 and again in 1996. So this idea that our ancestors came the legal way, and therefore why didn't this new wave of immigrants also do it the legal way, is a misunderstanding. The system we have is broken. All lawmakers agree that it is broken and it needs to be repaired. Now, just how we repair it is a highly debated point of contention. Nonetheless, it's broken and it needs reform. What's not helping the debate is continually demanding that people get in a line that doesn't exist, or making comments like, my grandparents did it the legal way, why can't they? Real immigration reform then might be to make a process that looks more like getting in line for the bathroom. There's a line, you wait in it, and you get in. For more information about this and other immigration matters, please feel free to contact my office. We're happy to discuss these issues with members of our community. You can find more information about Lighthouse Immigrant Advocates at www.lia-michigan.org. The Refugee and Immigration Collaborative, Connecting Global Neighbors. This collaborative was brought together with support from Calvin College, the Calvin Alumni Association, and the Calvin Center for Christian Scholarship.